The High Court on the judicial side has entertained a review and apparently gone beyond it on a mistaken impression, which is revealed at page 12. I'll just give your lordships the background. This is for 138 posts of civil judge, junior division, for which there were more than 21,000 candidates. Now, there was an amendment to the rules which permitted that the eligibility requirement is 3 years as an advocate and 70% marks. Yes, that amendment was challenged by way of a writ petition. It came up to this court, and on 15th of December, your lordships were pleased to dispose it on a submission that was made on our behalf, on the High Court's behalf, saying that those who do not meet this eligibility requirement will be permitted to pass. So treat the amendment as non-effective, subject to the outcome of the proceedings challenging the amendment. Now thereafter, the prelim exam is conducted. 926 individuals qualify in the preliminary exam. Broadly, they were looking at a 1:10 ratio. It became a little less than that. Out of the 926, 846 appeared in them. Yes. Of which 809 were general, 31 physically handicapped, etc. etc. Now, thereafter, on 30th March 24, the mains exam is held. Yes. So that exam has been conducted. Yes. Sticking to the original schedule which we had set out, on the 1st of April, this exam is held on 30th March. The next day, the High Court upholds those amendments to the rules. Yes. Now, because it was made subject, therefore, it requires an exercise now by us where we remove all those who did not meet the eligibility requirement under the amended act. So we have to weed out. Now, we are carrying out the weeding out process and sending those for the interview who do have the eligibility requirement. 2 individuals have filed a writ petition. The writ petition is dismissed at the outset. They file a review. Now, in the review, which is what the impugned judgment arises out of, please come to page 12. The 2 of them argue that they should have been permitted then to have been considered in that shortlist that was made for participating in the mains exam. Where is that? Page 12, para 11. Yes. To ensure purity and administration of justice, the least that is required is to prevent any ineligible candidate to secure appointment on the post of civil judge entry level. This is never going to happen. We are only going to ensure only eligible people as per the sustained amendment are the ones who are going to be appointed. So a review actually, the exercise. Yes, something like that. Yes,
the eligibility bar, which eventually was upheld by the High Court,
yes,
pertain to either 70% marks or 3 years practice.
Correct.
Right?
Correct.
Now, the 2 who have filed the review petition,
yes,
which clause they don't fulfill?
They will be ineligible. Okay. They will fulfill this. We have no doubts on the eligibility.
Okay.
They will fulfill it. But because the entire exercise was made subject to the outcome, and there were no other inquiries at that stage, we went ahead and had the prelims exam. Now, in the prelims exam, the entire pool, including these 2, took part.
Right.
There was a merit list drawn out of that,
right,
on which we have to shortlist out of this 21,000. We have to sort out who would qualify. 926 qualified. There's cut-off marks for each of them. So in the unreserved, the cut-off was 113.
Yes.
These 2 below 113. They fell below 113 marks as the cut-off because they're both general. There are different cut-offs based on the category, but in general they fell below 113.
Yes.
So therefore, the final list of 926 who had qualified for the prelims did not include them.
Okay.
Now, those who did qualify in the prelims went and took part in the main exam, which was held on 30th March. They were not among them. But because the judgment came after the main exam and the judgment upheld the rules, they say, because you sent 926, which included those who were not eligible as per the amended rules, those people should have been weeded out. They should never have been sent retrospectively for the mains. We should have been sent. We would have had a chance to move up. One, to be fair, would have been within firing range, 111 or so. The other was about 2 marks below that. So that is that case. So because we had already conducted the main exam from a pool, because there's no assurance that those two, even if they had come for the mains, would have qualified. We had conducted it, and we had to, out of that 846 who appeared in the mains, we have another stage of an interview. So those who have done well in the mains, their mains marks and the interview marks will be taken into consideration. Now what they want and what they have succeeded in partially is to ensure that those who are eligible and have made it through the mains can remain as they are, but a separate exam now has to be held for those who will remain after you weed out those who were ineligible. The only thing is to, bifurcate that process is a little difficult for us because we have to do an interview after this. So we are going to take one exam which has already been conducted, a new exam as per the impune directions, to make those two people eligible for what? Not for the appointment, but just to contest a main examination. That is the case. So in my view, in a review jurisdiction, perhaps the view that the court took, and I think it is premised on this para 11, believing that we would allow ineligible candidates to become, that would never happen. Out of this final list of 846 who appeared, Manoj, and took the mains exam, automatically nobody will be called for the interview who are not eligible. So there's no question of ineligible candidates being appointed.
It's perhaps the numbers may vary a little.
Numbers may vary.
Very a little.
Numbers may
So
vary.
beyond that, no ineligible person is going to get into
No question, absolutely not. There's no question. So I think they misdirected it. Yes.
One candidate has got 112. Another candidate has got 108 marks.
Yes.
For the logic adopted by the bench in the review judgment is,
Yes.
if at all we exclude
Yes.
those candidates who have been permitted pursuant to the orders,
Yes.
the benchmark is going to be stepped down.
Yes.
The benchmark is stepped down.
Correct.
They get a chance to
Correct. That logic is correct. I don't have a problem with that logic. That logic of the division bench is correct. The only thing is consequence. I'm sorry.
I appear for the capital respondents first.
Sorry, who?
I appear for the capital first.
Yes. All right.
Please, Manoj. I will accept the notice, Manoj. Before that, Manoj, one humble submission I would like to make, Manoj. A lot of the contentions of the petitioner throughout and through in has been that once the main examination has been conducted, now the situation becomes irreversible. Now, this aspect of the matter was, Manoj, at length and in detail, Manoj, considered by the Honorable Division Bench in its review order, wherein catalogue of factors, Manoj, were also laid down, specifying as to where the original court, Manoj, initially ordered bench and heard, Manoj. Now, only 77 candidates in the mains examination have been allowed to, Manoj, appear for the interview. Now, there another contention, Manoj. They were now all the eligible candidates. And what they have equated in the original order is that there is a benchmark. Now, there is a difference between, Manoj, passing marks and the cutoff marks. Once all the ineligible candidates were weeded out from the preliminary stage itself, then automatically, Manoj, the cutoff will have to be shifted, and it has to be considered in light of eligible candidates.
How much of that can be done in a review jurisdiction is one of the questions, and the other is whether any injustice is happening. We don't think that any injustice is happening in the manner. Obviously, there is bound to be inclusion and exclusion. That we understand, but then through the process that is being undertaken, I don't think there is any scope for any ineligible person to come into the reckoning for the purpose of appointment. That is the main concern.
Please, Manoj. Now, eligible candidates, Manoj, but I am the eligible candidate. And I would have qualified the preliminary examination, lock, stock and barrel, had those ineligible candidates were not there in the list, Manoj.
Mr. Manchanda, we can't be having a separate examination for yourself. You might have missed the bus this time, so you might have to take another chance. Right now, we are
not the separate examination, Manoj. My submission is the original examination is there, and they are not going to be tinkered with. That's my concern, Manoj. I'll accept notice, Manoj, your worship. I'll reply, Manoj, on affidavit.
In the meantime, the order has to be stayed. Yes. Or Mr. Gopal Shankarayan, and senior counsel appearing for the additional stuff. The counsel would refer to would point out that would point out that the amendment on the eligibility criteria for the post of Civil Judge Junior Division, prescribing either 3 years practice at the bar or 70% marks or minimum marks, minimum of 70% marks in the recruitment examination, correct?
Yes.
In the recruitment examination for the general category stroke OBC, the general stroke OBC category candidate though challenged, was eventually upheld by the division bench to the judgment dated 1/4/2024. Stop. The above decision of the High Court was upheld by this court, was sustained by this court through the dismissal of the SLP ordered on 26/4/2024. Stop. At that stage, the review petition was filed, and where the impure order is passed on 13/6/2024 with the mistaken understanding that an eligible candidate may be able to secure appointment to the post of civil judge. Stop. We have heard the contention made by the counsel, senior counsel would indicate that the results that were conducted, the examinations that were conducted was with due application of the amendment rules, and only those who had the eligibility, satisfied the eligibility criteria were allowed to sit in the examination. Stuff. The High Court therefore was not. Therefore, the High Court should not have exercised the review jurisdiction to direct recomputation of the preliminary marks. Stuff. That I issue notice returnable in 4 weeks.
No, just two small things. One, my submission is that they would include ineligibles who took part in the mains, but they wouldn't go further because they're apprehensive. So your lordship just said that the eligible candidates only took part in the mains. That may not be correct. That eligible candidate, there's no question of ineligible candidates being appointed after the court's
question of any ineligible candidates being appointed. Although at the stage of the examination, few ineligible candidates were permitted to appear in the written examination because of the interim order passed by the court. I think that's what you are saying.
That would be.
Issue notice. State operation.
We haven't asked for it. Have you asked for it?
Have you asked for it?
We've asked for an interim order. I was going to request that.
In the meantime, the operation of the interim order is state. Yes.
Okay. I'm good.